Pili inakuja na kuambia aje, uhuru wako wa kujieleza kwanza lazima ikuwe on a public interest. Sasa kwa hii public interest ni the government of the day ndio ilikuwa ina determine what is public interest. Unaona? So ukienda huko useme kwa mfano zile enzi za Moi ungesema hii serikali ya Moi ni mbaya. Unaona? Sasa si wao watasema serikali yenyewe itasema aje kwa public interest kitu umesema ni mbaya. So kumaanisha tushakata ile hiyo freedom yako ya kujieleza. Ndio maana wakati tulikuwa sasa kwa hii katiba mpya 2010 tukakieka hiki kipengee maalum. Na kwa hiki kipengee ukiangalia article sasa 33 sub clause 2 ambapo kinapeana limitations vitu ambavyo hupaswi kufanya. Kitu ya kwanza ambacho inakata ni hate speech. Unaona? Ya pili ni vitu kama incitement, vitu ambazo zitaleta mapigano. Hatutaki kurudi vitu ambavyo vilifanyika mwaka wa 2007. Hizo ndio vitu ambavyo vinafaa kuwa limited, but wewe kama mwananchi si ati upasi ku criticize the government. In fact, wanasema ukisoma kulingana na kesi zenye zimetoka, kesi za kotini Kenya na kuna kesi nzuri ya Malawi, wanasema our public leaders wanafaa kuwe na ngozi ya mamba, naweza sema ngozi ya mamba, hard skin, ili waweze kupewa vitu zinazowafurahisha ambavyo pia zinafaa kuwa chache, because majorly si watu wengi wanaona wakati tumewaelect kila mtu anafurahia, lakini wanavyoendelea kufanya kazi zao hawafurahishangi kila mtu. So wenye watafurahia ideally wataongea vizuri kuhusu hiyo serikali ama kuhusu huyo mbunge, gavana, seneta, wote. Lakini kwa sisi wenye hatujafurahia, our option ni gani? Kumcriticize. Sasa hata akienda akifungua huko CDF, hata akifungua tuseme hizi vitu za CDF, amefungua shule na hiyo pesa ya CDF, hata kama amefanya kitu mzuri, si tutasema aje, lakini pesa ilitumika huko si ni mingi. Ile tangi alijenga, si hata nyinyi mnaona inamwaga maji. Hiyo pesa ilienda wapi? So lazima tukue na hiyo equilibrium, tuna balance. So wao lazima wakuwe na ngozi ya mamba, waweze kutake in all that. Sasa hiki kipengee sasa utarealize kitakuwa kipengee kizuri wakati kila mtu ameweza kujieleza. Sasa hiyo iko kwa article 33(1), kujieleza vizuri. Na kwa huku kujieleza, kwa hiyo article 33(1) ningeomba niongelee hizo vitu zenye ina include. Inasema each and every person has a right to express themselves. Sasa ndio inaenda through artistic creativity. Ikitoka artistic creativity inaenda kwa scientific works na vitu kama hizo. So kwa hii artistic creativity sasa ningetumia hii kesi ya hao wasichana wa Butere kwa ile play yao. Utarealize kwa ile play yao ya kwanza mwaka wa 2013, serikali kwanza iliwakataza. Actually ilikuwa kuna hiyo body ya hizi vitu za music, ikawakataza wasiende kuplay now at the nationals. So kwa hiyo kesi Justice Majanja ambaye alitoaga mwaka uliopita alisema kuwa ukiangalia hata enzi za ukoloni kwa 90s tulikuwa na waandishi maalum kama Ngugi wa Thiong'o, Mishermu. Hata sisi tukiwa katika enzi za high school, sekondari, tulikuwa na watu kama Pauline Kea ambao waliandika Kigogo. So hiyo ni kitu ambacho kiko, na mwanafunzi ni vizuri aelewe haki zake akiwa shuleni. Ajue aje ako na hii haki. Hii haki inamsaidia vipi? Pia ukikuja katika sasa hii kesi ya Butere ya pili ya huu mwaka, ambayo ilikuwa na Justice Okwany, alieleza kuwa hiki kipengee, kwanza alipeana hiyo conservatory order akalift, akasema hao wanafunzi wacha waende wa play, na akasema ni vizuri serikali ambao niliwaambia kuwa inapaswa kuwa na ngozi ya mamba. Yaani wanafaa kuchukua tu kila kitu. Wanafaa kuchukua tu kila kitu mazuri na mabaya, so that ndio wa rectify. Kama ni watu wanaongea vibaya kuhusu, wana rectify. Sasa akasema kuwa kwa hao wanafunzi ni vizuri waende wacheze mchezo wao nationals, na kama huo mchezo haufurahishi serikali, akasema kuwa huo sasa ndio umuhimu wa hiki kipengee. Si kila kitu inapaswa kukufurahisha. Hata ukiwa uko nyumbani, si kila mtu anakuongelea vizuri. Kuna wenye wanakuongea vizuri na kuna wenye wanakuongea vibaya. Sasa pia serikali inafaa iko hivyo. Si kila mtu utachukia. Vitu zingine tu naacha tu ziende. Asante.
Asante sana Bwana Mila. Hebu tumpigie makofi. Kwa maana ameweza kuzungumza kwa Kiswahili kwa muda mrefu sana. Mimi siwezi nikazungumza Kiswahili kwa muda mrefu kama huo. Kwa hivyo tunakushukuru sana for the very, very wonderful presentation, taking us through the history of the provision from post-colonial times through the colonial government to the post-colonial government, and what is happening with the right to freedom of expression at the moment. For me as a discussant is mainly to challenge you to connect Article 33 to Article 32 and also to Article 24. How should we read, this idea of holistic reading of the Constitution? Ya kwamba tunafaa tuisome katiba kwa ujumla, sio tu vipengele moja moja hivi. So in that sense, my view is that this is maybe one of those provisions that has an internal limitation within it. Many of the other provisions in the Bill of Rights do not necessarily have that internal limitation. And therefore, there has to be a reason for this. Why we have these internal limitations? It's good to analyze that. And it's also good to see why we changed the language from the broad limitation clause of public policy to these very specific clauses of propaganda to war, incitement to violence. And so how do we do what we have been discussing here of balancing? At what point do we say that you have now misused or abused your right to freedom of expression? We've had scenarios in these countries recently, again with social media, artistic representations of the president that have made the president really angry. And you said they're supposed to have ngozi ya mamba, which means thick skin, okay? That our political class should have thick skin, ya kwamba wakipata criticism, wasije wakareact vibaya. So how do you draw that line? Also recently we had the case of an individual being taken to court for having written a book about the child to the president, the daughter to the president. And the question there is, do I have freedom niamke siku moja na mimi niseme kwamba nataka kuandika kitabu kuhusu Mwalimu Cedric Kadima, nimemjua kama rafiki yangu kwa muda mrefu, na nisimuulize wala nisiende kwake nikamwambia kwamba unajua Cedric, mimi wewe ni rafiki yangu, nimeamua nataka kuandika kitabu kwako. Na ninajua kwamba yani kuna vitabu ambavyo watu wameandika either ambazo zinaitwa autobiography na biographies, saa zingine bila kuwauliza wale ambao wanaandikiwa kuwahusu. Na huyu kijana nimemwona akiwa kotini hadi juzi, na alitolewa kotini pale ambapo the daughter to the president alisema nimemsamehe, na nikaanza kufikiri kwani alikuwa amefanya kosa kuandika kuhusu so again it's just one of those cases that made me think more about the freedom of expression. I'm happy you have spoken about the Butere Girl saga, and sometimes I don't know whether there is an instrumentalization of these provisions against certain people. We also had in the previous government some politicians. We now have the case of, for example, Oscar Sudi, who was taken to court over these matters. So I think there's a lot you could do with this provision, reading it together with the other provisions, including those that are going to be discussed here, and also picking up very good case studies on where we are with this provision and how the government has utilized it. And that's all for me. But before I pass to the next speaker, I want to invite Mr. Kobe to give his remarks just on this presentation in around 5 minutes, and then we can move on to the next provision, which is Article 34. Mr. Kobe?
Okay, thanks a lot, Dr. Mbori. Yeah. I hope I can be heard.
Yes, you can be heard loud and clear. We just can't see you, but it's okay for now.
Okay.
Yeah.
Okay, so thanks a lot, Oyugi Miller. That was a very good presentation, and this really brings out you have traced the history of the provision very well. But I just want to just to add on to what Dr. Mbori has said, I just want to bring in an aspect that you've talked about the fact that there are internal qualifications, for example, Article 33(2), but also I didn't hear you touch a lot on Article 33(3), which talks about that responsibility or in terms of respect for reputation for others and all that. Why I'm talking about that is that in the current context, for example, just to add on to what Dr. Mbori was saying, that remember currently, for example, in feminist spaces, there's this new idea about technologically facilitated gender-based violence, where, for example, women leaders are saying they are being harassed online and all that. So I'd expect that in your critique, you can bring in those contemporary arguments about whether because now, remember that now most of expression takes place in the digital space. Of course, when the Constitution was being written and when the struggle for constitutional reform in the 1990s and all that, we didn't really contemplate what takes place in the digital space. But that's really a new frontier that I think also should come out in your work, that in terms of contemporary challenges. But to go on also to the jurisprudence, you have highlighted very well, and I also join in commending you for bringing out, for example, artistic expression jurisprudence. But there's also, while we have done well in the jurisprudence, and most of our jurisprudence is very progressive, I also just want to urge you to look at some jurisprudence that I think is also really contentious. For example, I'm sure you came across the case of Wanuri Kahiu, the one on Rafiki film, yeah? Remember the film that was supposed to be featured in the Oscar or whatever competition, and then it had homosexual content. And remember, in that case, for example, you find that in the first instance, the judge who had the application for interim orders allowed the play to be played, but then after that, in the final judgment, the matter was dismissed, and they said that the ban that had been imposed by the Film Classification Board remains in place. So that's really, and the justification was that it was about, the judge was arguing based on public morality, that allowing such a film to be played in Kenya would corrupt public morality. And so, although as we speak, I know the matter is pending before the Court of Appeal, but it's something that also, I can call it some challenges that we still have. And just going to even the discussion that we had, that the panelists in the morning had in the previous panel, there's this thing of the proportionality test, how it's applied. Can the idea of public morality only And you know, something like public morality is a very, very subjective test. Can that be the basis for limiting our freedom of expression? So, but generally, I would just say that those were the two things that stood out for me that I thought you should have touched on. But I agree with you are bringing out that aspect that, unlike, for example, I like contrasting Kenyan Constitution Article 33 on expression and the American one. If you look at in the American jurisprudence, freedom of expression is absolute. But remember that due to our history, for example, as you have highlighted, the issues of propaganda for war, hate speech, you find that Article 33(2) has limited that, knowing our history, for example, with post-election violence and ethnic clashes. So I'd like that you brought that out, but you can consider those other two aspects that are brought out as things that I didn't hear you mention. But otherwise, thanks. Thanks, Dr. Mburi, back to you.
Asante sana, Mr. Kobe, for the very good comments. Kuna hili dhana ambalo limekuja juzi, linaitwa AI. Kwa Kiswahili sijui dhana ya AI kwa Kiswahili ni nini, rafiki yangu Jabez atawaeleza. And I say this because Walter brought it up. Digitally facilitated issues. Moving into the 2027 elections, vile ambavyo tunaenda, na vile ambavyo ninaona hii dhana ya AI inaenda ni, I think it's something you should consider thinking about. How far can we express ourselves with artificial intelligence? How far can we go? Now I see these videos, I don't know what they're called, where someone is, you know, it's not that person, but it's them. And of course you say, this cannot be Raila, because Raila didn't say this, I didn't hear him say this, but he's the one saying it. And this is something that we have to be concerned about. How do we govern this area from a human rights point of view? I think we should stop there for Article 33. Natumai mmeandika notes, na kama uko na swali ningependa ungoje tukimaliza, tukifika Article 37 utaweza kuuliza. And I know I know Elodie also is writing this paper together with you, so I hope she might also get a chance to say one or two things, but at the Q&A. Is that okay? Maybe we let it be at the Q&A because there'll be a bit of time there. But for now, I want to ask Betsy to take us through Article 34 of the Constitution. Welcome, you have 12 minutes.
Thank you. So my presentation will be a little different from Mila's presentation. I will not be speaking in Swahili. Also, I just want to start from where Mila left off, and in the spirit of reading the Constitution holistically. So Article 33 and 34 are very correlated, and just with the more progressive Constitution that we have. So Article 34, in its inherent history, did not explicitly exist before the 2010 Constitution. It existed within the broader rights of expression, so the freedom to disseminate information through electronic, print media was not explicitly recognized as a constitutional law under the Bill of Rights. So to have Article 34 in the Constitution and to experience the realization of Article 34, I think is the primary purpose why we're having this conversation in the first place. So the history of Article 34, again, is rooted in a lot of historical injustice, as much of the Constitution is. So Article 34, the freedom of media, if you trace the history of media and expression rights in the country, in the political scene and just in the democratic scene, a lot of it is, there's a lot of patterns to be drawn. I think the history kind of tends to repeat itself. Just maybe the actors have changed, or rather the objects have changed within the system, but the patriotic nature in which a lot of these events have taken place kind of play out through history in the same form. So when we got independence, so the 1963 Constitution did not explicitly recognize, and even before that, when we had the newspaper ordinance of 1906, a lot of that was curated to kind of limit the kind of, or control the kind of media that was being pushed out. So to neutralize nationalism, to kind of suppress the nationalist voice that was trying to fight for independence. So when we did get independence and we finally got to sit down and have a constitution, or at least we inherited the Constitution, the Bill of Rights, the Article 34 that we had, so under the freedom of expression, had defilement law, so it had laws kind of prohibiting you from sharing information without having it go through various assessments. It had to, and a lot of the time you wouldn't even get approval, which again translates to today, so with accreditation laws. And so Article 34, so the freedom of the media primarily rose or like became a focus point or something that was needed in our democratic society. In the 80s, in the 90s is when they kind of started championing for this to become an independent right, primarily because of the demographics it serves. So Article 34 and 33 are interdependent, are rather related because they all serve expression rights. But Article 34 kind of speaks to the institutional guarantee for the freedom to disseminate information from an impartial. So a lot of the time you'll hear the fourth estate. So the media sits at a pinnacle point where it gets to say what is happening without partaking in any side, and the government shouldn't necessarily get to pick a side or to control what is said about the government. So in the 90s, when civil society was rising, and we have Mutunga's book, actually, Constitution Making from the Middle, and we see with this, he kind of places civil society at the center of this liberalization and this rising radicalization in our need to seek emancipation from the oppressive regimes in the fight for multipartyism. And so maybe I could just tie it to 35 years on. We just recently had Saba Saba kind of replay. So the news articles had it saying 35 years anniversary, which inherently face value, that's not something to celebrate. But if you look at it from a civil society, or like what came out of that motivation, out of that revolution rather, is Article 34, out of that kind of need to separate themselves from state control. So maybe I could just also move towards the end of the 90s. So the constitutional committee, people had started getting together, trying to form committees to draft this constitution. Drafts were kind of in. So in 2004, when we had the Bomas draft was kind of the more liberal constitution. It envisioned a lot of, it removed a lot of the executive control. So it envisioned a lot more pluralism, I would say, and less state influence within the media system. And when that didn't pass, we got the Wako draft, and then which kind of aligns a lot with the Article 34 that we eventually got. And just fast forward looking at today, the current events that we're having in our society, just currently in the political space, in the democratic space, a lot of these, if you pit them against the previous drafts of the Constitution that we could have had, you realize a lot of it is systemic. So the patterns are the same, but a lot of it is kind of a repeated, it's a systemic repetition of political elements. I want to call them political elements. So with primarily Article 34 in its existence, it has 5 subsections, subclauses. So Article 34(1), which is kind of 33(3), that speaks to the limitations of articles. So it has internal limitations. So within the freedom to disseminate information, there's things you cannot do. So you will not spread hate speech. You will not incite war. Those are the provisions of that first section. And those kind of speak to the historical injustice that we've had, that the Constitution had to explicitly state this and put this in the Constitution, in the Bill of Rights. And so with that, we have 34(2), which speaks again to censorship, to state control. It speaks to state control, that the government may not interfere, that we may have the freedom to receive that information, which will tie back to the next article, so the right to access information. So the right for the media to disseminate this information and the right for the public to demand this information. And my fellow panelists will go into that much deeper. But with that, just being explicitly stated within the Constitution, you kind of realize the progressive nature of our Constitution. Is very progressive, and it tends to be very verbose. It's been known to express a lot, and a lot of the time it's because of our history. So we have a responsibility. These are the ideals that were held during the drafting of this constitution, that we may prevent the injustices that we've experienced as a country, and that we may continue to move forward with this, with the human rights normative framework, which is primarily the framework for this book. And I think something that has been mentioned with constant technological advancements. And so we're seeing a time where maybe Article 34 in its original drafting may not be sufficient, or at least may not be sufficient considering the loopholes that are currently existing. So for example, you would look at it this way. AI is not legally, it's not considered a legal person, or again, technological advancements with the rumored internet bill. So like you'd need your ID to access social media. So does that then inhibit your personal expression rights, or is that a limitation on your media rights, because on your freedom to disseminate information, which takes you back to the Media Council Act, which explicitly states who is a journalist, and so who is a journalist and gets to be protected under journalistic rights. So this so those kinds of laws that are coming up to try and limit, to try and censor sort of the dissemination of information rather, and expression rights and media rights, we bring up the conversation. So what does then qualify mainstream media? Because that is what the Constitution outlines in Article 34. Mainstream media is protected by Article 34. So is mainstream media then social media users who have a larger platform, or is it limited to these people who have, like what the Media Council considers journalists? Because 34.2 does not explicitly speak to journalists. That would be 34. So again, I think these are kind of the contemporary issues that we're grappling with, and these are the things that we kind of are having a conversation around, the contemporary issues that potentially have the ability to create loopholes within Article 34. So because this is a right that is very political and kind of is affected by these social issues and social developments in the long run. So I think, looking at it in retrospect, have we progressively realized Article 34? From where I sit, I would lean towards, yes, we have realized I lean more towards the yes, we have realized Article 34, considering Article 34 did not exist explicitly. So to have it, and to have, so the recent Communications Authority seizing the recording, or rather the dissemination of the protests rather. So at a different time, before the Article 34 explicitly existed, that would be controlled, or that would be prosecuted because it is a matter that is going to court. That would be looked at from a different lens, not a constitutional Bill of Rights type of provision. So to have that, and to have the court immediately say you can't do that, that's unconstitutional, is a progressive realization. It is not as much, it's not what you would think. It is not a golden realization, but it is something. You were making steps towards these towards the realization of human rights. So the right to basically express those political ideals on a journalistic platform, which I would argue is as an administrative role, or rather is not a personal. A lot of the time it is in your journalistic capacity. You're not specifically speaking to your personal ideals, because it is, again, with expression and media freedoms, expression is, you have a lot of individual freedom to kind of decide what you want to share. With journalistic freedoms, you're kind of limited to editorials, you're limited to company policies, you're limited to a lot of things. So again, that kind of creates this separation that is important, because if you're speaking on behalf of editorials, if you're publishing in your name, but that went through an entire editorial process, do you then suffer the brunt for publishing political, or which you shouldn't, because again, state control, but do you then sit at a point where you are facing treason charges? Because this is something we've seen in the African court, where you're facing treason charges for basically putting out information that was aligned with terrorism. Are you then a part of this greater form of terrorism? So I think that is the much I can say. We could still speak to this more in the next coming sessions. Yeah.
Thank you very much. Let's give a hand. Thank you very much, Betsy, for that very good and wonderful overview of this provision. I really appreciate it. Mwanadada huyu amekuwa akizungumzia uhuru wa wanahabari ama wanahabari katika kipengele cha 34 cha katiba. Na anasema kwamba kipengele hichi ama hiki, Kiswahili kinanisumbua niliwaambia, kinafaa kitofautanishwe na kile kingine in Article 33 ambayo ni ya mtu mmoja, na hii inahusisha watu jumla ama kikundi ama organization, so to speak. So I think that this is, for me, I think you've done a very good overview and coverage of where we are coming from. I would add a few things and push you a little bit in certain directions. It's important to say that this is a new provision. It wasn't there. It has appeared in the 2010 Constitution. But what really inspired that? And I don't know whether you might have been old enough, but some people here in the audience might know there was a time where mke wa Rais Kibaki, wakati mmoja alienda katika kituo cha wanahabari cha KTN. Kule ndani akaingia ndani akawaambia kwamba hamwezi mkachapisha habari kama hizi. Na mara nyingi wengine wetu tulisema huo ni, it's a limitation of or censorship, so to speak. And I think this might have happened, I don't remember the year well, maybe before or during or just after the 2010 Constitution. But before that, I think maybe I might be just a little bit old enough to also know that for a whole generation, this is, millennials might not even have experienced it much. There was just one news channel in the country, just one. And before that, it was VOK, then it was KBC, and all news in the country used to start with where the president was. Mtukufu Rais, Hileo. Exactly, that's how news used to start on the radio. Mtukufu Rais, Moi, Hileo alikuwa this and this. Exactly that. And so this idea that news can start with other news for a generation, maybe the generation just before mine, boomers, will tell you they didn't experience this variety that we are experiencing. And because there was very limited media, the state had a lot of hold on that. And it might be interesting to trace that even that history from a narrativization point of view. Like I've said, even I might not be, old enough to give you the details, but najua kuna wengine hapa ambao walishuhudia wakati huu ambapo kulikuwa na KBC pekee. Kifungua televisheni ni KBC, hakuna kitu ingine. Wakati huu kuna channels nyingi, you can watch very many things. So that's one area. The other area is who really is the media. Ni nani mwanahabari ama ni kikundi kipi ambacho tunaweza kusema ni kikundi cha wanahabari. Now we have the internet, but beyond the internet we have this proliferation of podcasts. I don't know, I mean in this country now there are a million podcasts out there, and each and every of them is disseminating all kinds of information. How and to what extent are they covered by this provision and this protection? It will be something interesting to think about. That, and also I know you've mentioned citizen journalism. Tumeona siku hizi mara nyingi kukiwa na tukio mahali, kama sasa hivi kukiwa na tukio hapa nje, hawa wana Gen Z watachukua simu hivi waanze kupiga waweke kwenye live, na wakati mwingine maybe it is a gory image that a media personality will not, for example, present, or they will try to protect, or maybe there are children involved, and citizen journalists don't know that. Again, there's these questions of how far can we go, or how far have we gone, so that then it ceases just being a question of vertical application, i.e., this right is the right for the media against the state. It might also be there's a right that is horizontal, that then applies not just with the state, but also amongst us. And I guess this is my, I implore all the speakers here in this, doing this analysis, to not just think about this rights through a vertical application of human rights, but also horizontal application. Those are my comments, so thank you so much. And again, I will welcome Mr. Kobe to give his discussion comments in 5 minutes, so that then we can move to the next provision.
Thank you, Dr. Mbori. And thanks a lot to Betsy Kirui. I think that's a very comprehensive analysis of the background of the provision. Let me just start by saying that one thing that we must recognize is that if you look at comparative constitutional law, you'll realize that most of the Bill of Rights have just the right to freedom of expression. They rarely have this protection of the freedom of the media that we have. So that you tend to find that it's actually, in most countries, it's actually media, if you want to litigate on that, you litigate under freedom of expression. So that really shows you how advanced our Bill of Rights, or how modern it is. So that's just the first point I wanted to make. Second point I want to make is that, and it's good, Betsy, you brought out some facets that were really not really captured in the provision of the new contemporary challenges. I want to bring out one that is about a matter that is actually really live now, is about the issue of, for example, award of tender now for advertisement. Yeah, that remember that in the last few years, the government has been unhappy with some media stations. What did they do? Previously, they know each state corporation, for example, would go and advertise with a media company. But then what the government did is that they now have a pull-out where all adverts for government is, and then they decide which media house to be given. And then you find that they give it to media houses that are friendly to the state. And so these are the media houses that are critical to the state now complain that how comes us we're being punished commercially. And so that's something that you really must look at as a new way of suppressing the media. And in fact, there's a court case that is going on, but as also Honorable Imanyara reminded you in the morning, in fact, there's also a case that was decided this year, a Law Society of Kenya versus PS Kisiangani, when the PS directed that all adverts by the government should be given to KBC. So what I'm bringing out is that, unlike before where, for example, and what the Constitution thought was the problem of, for example, the being given a license, now, although the government will give you a license, they have now found a new ways of punishing in a soft way media houses. So that's something that I really wanted to look at, follow that aspect, to see how it can come under this protection. The next thing I'd suggest you look at is about what we call prior restraint orders from courts. Of course, there never is, that is, prior restraint are issues where, for example, when I, as a politician, for example, I know that let's say national media is planning to publish some news story that is inimical, or that goes against my interest, then I rush to court and get orders of injunction preventing that publication. Although you'll find that they're not litigated as constitutional issues, but they really have direct effect on freedom of the media. So you'll find that, but I would say that our courts have been very, very progressive so far, because you find that it's only in very, very rare circumstances do they bar media houses from publication. But it's an issue that really affects freedom of the media. So I'd really want you to look at that aspect, follow up on our prior restraint cases, whether our courts have really, really incorporated or have really taken into account the need to protect the media when such cases are brought to court. The third aspect I'd want to also look at is about award of damages. Because I work in the Office of the Chief Justice, I've attended the interaction we have with the media. And one of the issues that you get from the editors or from media houses when they engage with the judiciary, they tend to be concerned about what are the amount of damages that are awarded against media houses in defamation cases. Because remember, some of our media houses are not really that financially strong. So if in each case they are getting awards of 10 million, 20 million against them and all that, if if you have 5 such awards, they'll not be able to pay the journalists. So that's something that really has a serious effect on the freedom of the media. So look at it that, or I would suggest that you look at that trail of thought, that you can look at some of the defamation cases and really our trends, our jurisprudence on award of damages, whether it's really protecting the freedom of the media or not. And so those are really some of the issues that I thought I will bring out, but I think you've really, and as Dr. Mburi has said, you've really covered the history very well. Thank you.
Thank you very much, Walter, for that. I think, very judicial perspective views that I also find very, very insightful, i.e. how the government is, trying to circumvent these rights in an indirect manner through the advertisement space. I find that very insightful. But also the coordination between the law of defamation, damages, and how the judiciary has played that role. And I think Betsy, and I think you have a co-author too. I don't know whether he's here. I think he might get an opportunity to comment also in Q&A. It might be important to sort of incorporate some of these discussions into your paper, and I'm sure it will really, really enrich it. So thanks again for the wonderful presentation. Because of time, I really want us to then move on to Joe Karaoke, who's then going to cover the next provision in the next, and I think this is a single author paper, in the next 12 minutes. This is Article 35 of the Constitution. I beg your pardon. So you have the floor, Joe.
Thank you, Dr. Mburi. First of all, I don't know if I'll use all the minutes. I want to be as concise as possible, but also...
That would be great.
Yeah, concise as possible, but also, relay information as it is. So I can start by saying that right now on the internet, we really have a lot of information on stuff. And most lawyers know that getting readings or even cases that were there before the 2010 Constitution is really hard. And majorly because documentation wasn't there and the information wasn't there for public access. So whatever the state did was secret. And for you to get information from the state, you had to give reasons why. And I'll start by giving a comparative analysis on what we have now and what was there. Why is Article 35 of the Constitution really unique? So first I'll start by saying that Article 35(1) grants every citizen that privilege to access information that is held by the state, and this is what we call vertical access. So before we had this particular provision, I can recall from what I have read, I haven't experienced it in firsthand, so there was that sort of secrecy in the previous administration, starting from even before we had an administration, maybe the colonial period. So there was this Official Secret Act. Before it was the ordinance, but now it later on came and became an act that really gave the state power to withhold the information that concerns them. And this is arbitrary because now people couldn't know what's happening. And that's why we had so many things happening in the back that weren't explained. And if you dared ask why this and this is happening in the state, then the people who experienced the first-hand thing, we have Wahome, Mutahi, they can tell you what happened to you. And the judges say that unge salimio kidogo, or unge bembelezwa. So the information that was in the state was for the state alone, not for the public. And the reason why we know what we know right now is because of the few people who stood out and started disseminating this information, even if it was against the will of the state. Gitobu Imanyara is one of the examples that I can give, together with the one who I just mentioned, Mutahi. They really stood out to critique what was happening in the government, and because of that, Gitobu Imanyara, between 1989 and 1991, he really went through a lot because he tried to reveal information to the public that was secret to the government. So I want to also bring out another aspect, and that is horizontal access. And this wasn't there. And so I can start by saying that the term every citizen has been used to show that whatever we have for the state is ours. And it is a regression for us, according to other analysts, but for our state, we can say that the term every citizen, there is every person, most of the provisions, even in the international law provisions and other principles like the Shuane principles, which speak of this particular right, use the word every person. But Article 35(1) specifically states that the right to access information held by the state and held by other actors who are of horizontal level is primarily given to citizens alone. And this because they give us the privilege as citizens for our information to stay inside. So no one from outside can come and start telling us that they want information about something happening in the country. It looks off. But yeah, so right now, every citizen can access information held by private persons. Yeah, and that includes juristic persons. That can be a corporation or a body. Yeah. So Article 35(3) gives the state what we call a proactive duty to publish and publicize information even before we ask for it. And this wasn't there before as well. And that's why in the 1963 administration, you had to, and it's very different. Right now we are presuming that everything that the state does is presumed for disclosure. But what was there before is that you had to demand for information. It wasn't assured that the government will provide it. So, and that's why they say that it was a secretive kind of government, and that's why they gave it the term serikali rather than serikali, if that makes sense. Yeah, so right now the state has a proactive duty to publicize important information affecting the nation, and that is what caught my eye. What do we mean by important information? So, if I want today to go and ask for information about terrorism and if the president was involved in maybe an act of terrorism, that is just a hypothetical case.
Okay.
So they would...
You have to emphasize.
Yeah, so they would deny me access to that, maybe because it concerns the president, and maybe because they will take an exception of national security. They will say that revealing the acts of the president or something will affect national security or something. Yeah. So right now we have exceptions such as the national security, but they are well explained. And when a person, they are well explained when a person can actually give the exemption of not disclosing information from the state using the exception of national security. And those can be found in the Shone Principles, which are global principles on national security and the right to information. Yeah. So, and what I actually found to be important in this part, what comprises of important information, is that the government and the government only has the power to decide on what is important. Everybody else, including the horizontal level private bodies, do not have that power to say that whatever they have is important information affecting the nation. Yeah. So on Article 35(3), that is what I have to say about it. Yeah, and just to give a small history of what happened, of which most of the things were mentioned, is that after the WACO draft and after the harmonized draft was there was another discussion in the Naivasha draft, or what they call the PSC draft. And on this part, there are people who didn't want the Access to Information Act, or the Access to Information as a right, to be a standalone right. And they say that it should be under or embedded in another right. And I don't know why they will suggest that, because previously that was the major problem, is that access to information wasn't a standalone right. It was under Section 79 of the freedom of, was it speech? Expression right, of the repealed Constitution. So, and that was the major problem that was there. But during the final draft, when they were making the final draft, they sat down and actually realized that this particular right is at the very heart of transparency and accountability. And that's why it should stand alone. And apart from promulgating this right as a standalone, they also gave it some enablers. So they came up in 2016 and brought out an Access to Information Act, which helps, give more clarification to the particular sections that we have. And also, we have the Commission on Administrative Justice, what was mentioned earlier as the Office of the Ombudsman. So in case you require information about something that is withheld by the state, then a request can be processed through the Office of the Ombudsman, and then using the timelines and the procedures mentioned in the Access to Information Act, then you can then receive your information as you need it. Yeah.
Thank you very much. A round of applause for Joe. I think that he has also done a splendid job. Amefanya kazi nzuri sana. Ni haki ya kupata habari or information. So this is Article 35 of the Constitution. So for me, Joe, ulipoanza nilidhani kulikuwa na tashwishi kidogo. It seemed to me as if ulikuwa unachanganya 33 kidogo na 35. Naelewa, this is important. Mara nyingi unaweza kuchanganya because the right to access information and the right to disseminate information are very close. And this is why you and Mila and her co-author should work together to some extent, because I think there are many places where these rights possibly intersect. And I think across the panel, really, there are very many places where we can learn from each other, share with each other. So don't work in silos. That's the first sort of, general commentary I would give. The provision, I think you've covered it well, including this idea that every citizen, meaning that this is different, ni mwananchi pekee ambaye anaweza kupata. And here I might be picking from Walter's initial comment on comparative analysis. I know, and this is very important for me, that in the US, anyone in the world, according to their Freedom of Information Act, can actually do a FOIA, which is the procedure of getting information. You don't have to be a US citizen to seek information kutoka kwa serikali ya Amerikani. Mtu yote duniani anaweza andika na anafaa kupatiwa. So it's a right for everyone. Lakini hapa Kenya tumesema kwamba ni mwananchi pekee. And I understand, na ni vizuri ya kwamba umesema si mwananchi ni mwananchi wa kawaida, na pia non-natural persons kama kampuni pia zinaweza kuwa wananchi katika sheria. I think that's an important point you made. But I think it's important to engage with that. Have we given the full extent of this right even in the Constitution? Or by putting citizens, have we limited it too much to the extent that, there are very many other non-citizens ambao wanatoka katika jumuiya ya Afrika Mashariki, ambao wanaishi katika nchi hii, watu wengine ambao wanatoka nchi zingine ambazo wanaishi katika nchi hii, na hao pia wanaweza taka kupata habari. So I think it's important to think about that. So that's number two. Number three, there's this notion that every person, this is very different, 35.2, which I think you should concentrate on a bit. It's now not every citizen. Si kila mwananchi. Sasa imekuwa every person. And this is within the same provision. So again, what were our drafters thinking? Why is it that when you are going to access information, it's every citizen, but when you want that information to be corrected, to be deleted, if it is untrue or misleading, now every person enjoys this right, meaning everyone else in the world. So what's the reasoning here? And here there's some comparative work that can be done across Africa. I think the most advanced part is Europe, with what they have called the right to be forgotten. And they really implement the right to be forgotten. Ya kwamba uko na haki ya kusahauliwa. Hawa wazungu wana mambo, uko na haki ya kusahauliwa. Kwamba mtu akisema kitu mbaya kukuhusu na aiweke katika mtandao, baada ya miaka kama 10 hivi, unaweza enda ukasema mimi nataka mtoe habari hii kwa sababu nina haki ya kusahauliwa. The right to be forgotten. I find it, and I think this is an expression. I don't know what you think, but I think this sounds to me like the very right to be forgotten. And everyone then has to implement this, especially on the internet. Google, for example. Kwa hivyo mimi nikikutendea tendo mbaya leo na uiweke katika mtandao wa Twitter ama Facebook, ambao siku hizi unaitwa X, Twitter, baada ya miaka kama 5 hivi naweza taka waondoe hizo habari mbaya. And I think in Europe it is implemented very strongly. If you're looking for negative information about me 10 years ago and you're in Europe on Google, you won't find it. It's censored. I mean, how does that relate with horizontal and right to access information? We want to know how bad you are, so that labda kuna tabia tu mbaya. Wewe ni mtu wa tabia mbaya tu na unaendelea na tabia mbaya. Sasa baada ya miaka 5 labda bado hata hujabadilika, bado uko na tabia mbaya na unasema kwamba hatufai kujua. So I think that's important. Finally, legislation, and I told you I'm working on this right access to information, so I might say a bit more. There is the Access to Information Act 2012, and the Access to Information Act 2016 says that you're supposed to go to the Commission of Administrative Justice if you want information. So mimi nimejaribu, niko nataka habari kutoka shule kadhaa nchi hii ambao nina wanafunzi ninasomesha na rafiki zangu wengine. Katika hizi shule siku hizi wanaweka school fees ambazo haziko katika sheria, hidden fees nyingi sana. Mara walimu wanataka wapewe tuition, mara walimu wanapewa, it's so much, and so mimi nikawauliza hawa walimu, this is something that is going on. I'm doing it right now. Kenya High, Kakamega High School are among the schools. Kwa nini nyinyi mnipe habari kuhusu hizi hidden fees? Mniambie kwa nini mnafanya hivi? Nilituma barua kama 5, 6 hivi, hata moja hakuna mtu alinijibu, hata moja hakuna hata mtu alisema Bwana Mbori nilipata barua yako. Unajua hata kukuambia tu nilipata, hakuna mtu hata mmoja alijibu. Haya, mimi nikasema kwamba nina haki ya kupata habari hii. Nikaandika barua kwa Commission of Administrative Justice, ikaenda kwa Commission of Access to Information. Baada ya muda fulani wakanitumia barua, wakaniambia hao ni wazuri, wakaniambia tulipata barua yako, tunaelewa haki yako, na tumeandikia PS wa Education, tumemwambia tupatie hii habari. Hii ilikuwa inafanyika mwaka huu Januari, na tunangoja, na tumempa siku 7. Kusema kweli hadi leo hii bado nangoja. Nimeandika email kama 5 nikauliza, jameni, habari hii imefikisha wapi? Mara wakajibu wakasema tunafuatilia, unajua kuna maneno mengi ambayo yanaendelea. And to me there's a problem here. Why? Because there are no timelines. I don't know whether you have seen any timelines. There are no timelines about how I will access this information. And also, I don't like this centralized system where I have to go to the Commission of Administrative Justice, and then the Commission of Administrative Justice is going to the people who have this information to ask them to bring it to me. In the US, you have the right to go directly to the person you're seeking the information to, and they have, in the Access to Information Act, about 60 days at most to give you that information. And many of them have created a system that really works. I don't know, and I don't know whether any one of you has tried, but in my view, our access to information processes, lived reality, I am now going to court next. Walter, please, you have the floor. I'm sorry for making a long commentary on this.
No, that was insightful. Thanks for that. So thanks, Dr. Mbori, but also thanks, Joe. I think you have done a very comprehensive review of the provision. In fact, I joined both Dr. Mbori and Joe in seeing the main problem, which I've always had, is the qualification that the entitlement is to citizens. Yeah. So I'd ask you to look at, I think where the problem came from is during the constitution-making process. If you look at, and you've touched about Naivasha, I always say Naivasha was the problem, where they even wanted to do away with the right and all that, yeah? So look at that constitution-making history that you've touched on a bit. I think that's where the problem is. And just to join what Dr. Mbori is saying, if you look at even our neighboring countries, South Africa, Uganda, and even Nigeria, they have the Access to Information Acts. And in fact, they say every person. So you wonder how comes in Kenya we have a very qualified one of every citizen. So I think really I've never seen the justification, but I think that those are things that you can even bring out in terms of reforms to really make this really actual, because really I don't think it's justified. Beyond that, what I wanted to bring out also is this. It's in our jurisprudence. I have another problem with our jurisprudence, although I work in the judiciary, so you would find it contradictory, but I have a problem with something that I want you to bring to maybe look at. If you look at the Supreme Court's jurisprudence and the SGR case, remember the SGR case where Okia Mtata went to challenging about the SGR contracts and all that, yeah? And one of the issues in the SGR case was about the availability of the contracts and all that. And so the Supreme Court says that, these things were leaked to Okia Mtata by a whistleblower. So the court says that these documents are not admissible. Why? Because we have access to information laws, that if Okia had wanted these documents, he should have gone through the long way that you see Dr. Mbori says is very difficult. This court says that you should have gone along that way. Now that you got these documents from leaked documents, you didn't follow the path of access to information, then we won't admit them. So that's in the SGR case. The second case, the same way, I think the first time then the court pronounced it, is in the Harun Mwau case. Harun Mwau versus IBC. Remember after the nullification of the 2017 presidential election, before we went for the rerun, there was some disagreement at the IBC where the commissioners were fighting amongst themselves. So there were some documents that were leaked from IBC. And then these documents, they were also to be used in the case that followed the repeat presidential election. And in that case also, you find the Supreme Court also struck out that those documents from IBC, because they had been given out by whistleblowers, they could not be admissible. And that the right route to follow was to use the access to information laws. So I've always struggled with that reasoning, where now you find that due to the fact that we have an access to information laws, we we are not appreciating that there are certain things that a whistleblower, when a whistleblower takes whatever, I can say is patriotic duty. Because if you look at all scandals in this country, from Goldenberg to all of them, we have always got, the public has got this knowledge about this misdeeds from whistleblower reports. But now the courts are saying that those documents, because we have access to information act or laws, we will never admit such documents. So that's something I've struggled with, and I'd really urge you to look at whether it's really justified. Because for me, it's not justified. And now you find that it's somehow introducing a way we use access to information laws to introduce opacity or to immunize really governmental deeds that we thought that we were going to use these laws to fight back or to shine a spotlight on them through transparency. So that's really the one area that I'd want you to add on to what you have said. But otherwise, a good coverage of the provision. Thank you.
Thank you so much, Walter, and also for giving us that. I think it's a great insight to think about how the judiciary has dealt with this. And I like that you say you're in the judiciary, but you criticize it. We are very happy to have you there. So continue with that criticism, internal criticism, as we call it. It will cause us some very good. It will cause us good in the country. So for now, ningependa tusonge tena. Tuko karibu kumaliza. Msije mkachoka sana. Ekeni maswali yenu, mtayauliza wakati ambapo utafika. Nimeona watu wachache wakisinzia kidogo. Naelewa ni baada ya chakula cha mchana. Chamcha. Waswahili. Waswahili wambobea. Chamcha. Kwa hivyo ningependa ukiwa umekaa na mwenzako hapo karibu na unaona ni kama anaenda kusinzia, umgonge kidogo hivi mwambie tunaendelea. Tuko karibu kufika katika kipengele ambacho mnakipenda sana. Kipengele cha maandamano. Kwa hivyo ukiwa umelala huenda hutapata habari ya maandamano, na tumekuwa na mambo mengi sana katika hii eneo ya maandamano. Kwa hivyo msilale, Wakenya msilale. Wakenya msilale, bado mapambano. Otieno Kajwang. So we move on. We now want to move on to Article 36. Crystal is going to take us through Article 36, freedom of access to information. You have the floor for the next 12 minutes. Also an individually authored paper.
Thank you so much.
Freedom of association.
I am going to try to do this in less than 12 minutes. So Article 36 guarantees the right of every individual to join, form, or participate in activities of any association of their liking. And this right plays a very key role in democracy and civic engagement, and I see why it was put together with freedom of assembly in the 1969 Constitution and Article 80. But then again, historically, and I'm doing this drawing from the colonial era all throughout post-colonial era down towards the 2010 Constitution. So colonially, this right was not meant to flourish because colonially, it was treated as a threat. So associations were the ones used to question or to challenge the colonial rule. Yeah. So the statutes at that time, like the Native Ordinance, the Native Authority Ordinance, and the Societies Ordinance were used to control and ban associations. And this is seen a lot during the Mau Mau uprising. Post-independence, and I'd bring this from 1963 to the early 1990s, the right was provided for in the 1969 Constitution, but then it was restricted in a very broad way, and it was restricted, I believe Mila has mentioned this, it was restricted in relation to public interest, but then there wasn't a particular explanation as to what falls under public interest. So it was just restrictions allowed in the interest of order, security, and morality. And I believe that this was so broad to the point that it allowed for arbitrary control of this right. And then moving on to reforms, and this is all through 1990s to the 2010 Constitution, civic engagement played a key role in making sure that this right is included in the 2010 Constitution. So the Constitution in the Kenya, like the CKRC, And people generally were of the opinion that this right should be excluded from the history it has suffered of arbitrary control and yeah, just that. So this is seen in the repeal of Section 2A of the Constitution and the reintroduction of multipartism in Kenya. The rights provided for in the 2010 Constitution. So you have Article 36(1) providing for the article very clearly as compared to how it was in the 1969 Constitution. And then you have 36(2) ensuring that, or rather reinforcing the fact that everybody should enjoy this right without coercion or being forced to join any association that they want to be part of. And then you have 36(3), making sure, rather protecting this right from whatever it had suffered throughout history. So it says that registration should be done fairly and free of arbitrary control. And I'd say that this right has gone through a lot. I believe Betsy has mentioned, and I believe I'm picking a trend of suppression here. So generally, this right and associations generally have suffered from suppression, from colonialists, and then the government as well. But I believe at this point, we are progressing towards a more inclusive and more participatory realization of the right. Yeah, thank you.
Thank you. A round of applause for Crystal. That was short, succinct, and very, very clear. And I think, again, I've said this a lot, there is a lot of intersections between the rights that are being discussed here. So there will be a lot to gain from what Mila is doing, what Betsy is doing, what Joe is doing, and what their other colleagues are doing, to just see how these rights interact with each other. Structurally, it seems to me, and this is a question that I want you to think about, it doesn't seem to me like the right to freedom of association in itself has an internal limitation of the kinds that we have been seeing with the other rights that are associated, right? So does it therefore mean that the general limitation clause applies? And how far can this be limited? And what do all this legislation that have these provisions on freedom of association have? I thought you would mention the elephant in the room. I don't know whether you know the elephant in the room. Tuko na ndovu hapa katika hii room yetu. This expression in Kiswahili doesn't make much sense. But kuna kesi ambayo ilihusisha kipengele cha hii LGBTQ. I think it's Eric Gitari. Eric Gitari was Freedom of Association Michel, right? So and you know how the reaction, you know the reaction of the nation to this. And the Supreme Court received a lot of backlash. I don't know whether Walter was already within the Supreme Court on that decision. And there was very strong dissenting opinions on that decision. We have recognized gay rights or LGBTQ through the right to associate. So it is possible that people are saying the gay rights do not exist or are not protected in our constitutional framework, but through this case, we are saying that they have a right to freedom of association. And this is something that is important to think about. Not just that the Supreme Court has affirmed this. I think this for me, apart from the qualms I have with proportionality, Walter, is a progressive decision. I just want to be on the record, that it is, but it caused a lot of fire, more than light, when people discuss this. So I hope you can engage with that, and how far does our association go? So if today, me and my good friend, Mr. Jabez Oyaro, decide that we want to form an association for neo-Nazis. You know neo-Nazis? Yeah, we want to form an association of neo-Nazis. Are we as far as the US? Because it might be possible that the US, in the US, this is acceptable. Or is it that here we might say, there you have gone too far. And what is that too far? What is the realm of too far that we can go when it comes to the freedom of association. And there's a lot of legislation when it comes to the freedom of association, and very many groups have formed, alumni organizations and all sorts of groups that this right affects. And like you said, this right is at the core of democracy. Finally, the Political Parties Act. I can see I'm being told time is up. Okay, Political Parties Act has, I wanted to mention that, but maybe Walter might. We are moving towards the end. Walter, you can give your commentary on this because I know you surely have, and then we will have the last right before we go to Q&A. I already see Sam Ngure mentioning that time is not on our side.
Okay, thanks. I'll be brief, and thanks a lot, Christoph. So I'll just say, just like Dr. Mburi, I think currently contemporary Kenya, where we are seeing a lot of the fight here is in the public morality space. So as you mentioned, that even in the previous constitution, there was a restriction of association on public morality grounds. So now you see the case that Dr. Mburi has talked about, NGO Coordination Board versus Eric Kitari. You also see even atheists in Kenya versus Registrar of Societies, yeah? Where some people were against that. And even Registrar of Societies at first declined to register the atheists in Kenya, the association. Of course, unfortunately, if you read that judgment, find that the court really adopts a strong Article 47, right of administrative action reasoning, but it really should have even brought out this freedom of association grounds. So that's really a space where you should really look at it. The second thing, and the last one I would just want to say, is also that right to refuse to be associated. One of the things that is coming up also in litigation now is, for example, those who want to join, you have heard of prominent lawyers who want to join clubs or whatever, these country clubs and all that, yeah? And they have been declined, and they are coming to court to force themselves to be members, yeah? So that's also, those two areas I think are really interesting areas that I'd want you to explore. Thanks.
Thank you, Walter. Does that mean that a boy can want to join the Girl Guides? Or a girl wanting to join the Boy Scouts? Question on the table. We are now at Maandamano, our very final presentation. I want to tell you, Mwalimu Cedric, people have been waiting for this. You have to deliver, because Maandamano is a big thing in this country, at least recently, last year and this year. And we have a right here in 37 that talks about this, and he's going to crown it for us because he's our final presenter, and I know him to be a wonderful presenter, and I know he will speak a little bit or even more in Kiswahili than I can. So you have your 12 minutes starting now.
Thank you, Dr. Mbori. You've placed a heavy responsibility on me, but I don't plan on disappointing. But I'm also glad with the other presentations. I've had quite a number of things which I'm really interested in and are intertwined with the right to assembly, or quote-unquote maandamano. When you look to your constitution, you'll see Article 37, which dictates that every person has a right to peaceably but unarmed. I think it's the only right that begins with a limitation. I'm not so sure. I don't know if there's any other right that begins with a clawback clause. Peaceably and unarmed. To assemble, demonstrate, picket, present petitions, and sorts. So you'd see there are a number of terminologies included in that right. But I think the most common one that is known to people is the right to assemble and demonstrate. I don't think most of you might know what picketing means, or maybe presenting public petitions. Mnatambua tu maandamano, si ndio? I think I was really impressed last year when buddies, all of you know buddies? Wazee kina mama hapa mnajua buddies?
Buddies ni watu ambao wanamili tu, yani buddies, yani bodies, ama unamaanisha vipi?
Yeah, buddies.
Oh, buddies, okay.
Yeah, buddies.
Hawa Gen Z watawaambia buddies. Yule rafiki yangu Michelle Gen Z anajua buddies.
Yeah.
Nina hakika anajua buddies ni nini.
But you cannot be from Kakamega and be a buddy. I think this is for only Nairobi people. Buddies were there in the street. during Mandamano, and they will be interviewed by media people. They will always say, we have a right to be in the street. What right is it? They will not know. They just know they have a right, but they don't know what that right entails. And they would always sing, or they will always chant, we are peaceful. So this is what that right entails. You can only enjoy this right if two things have been met. You are unarmed and you are peaceful. And this right has quite a lot of history before it was coined the way it is in the Constitution of Kenya 2010. I'll just start you off by going back to the colonial administration. I don't know if anyone has done research as to how the local setups, for example, my kingdom, the Wanga kingdom, organized protest back then. I don't know if anyone has done such research. I don't know if somebody has done research of how maybe the Luo community, before missionaries came in, were able to exercise their right to assemble, demonstrate, and picket. I'm not so sure. We always start somewhere in the colonial period. Maybe that's part of colonization that we need to decolonize. But when the British came, they had a very interesting approach to this right. And this was a command and control mentality that they had towards us. So every approach that they took was towards limiting this right rather than enhancing enjoyment of the right to assemble and demonstrate and also to picket. For instance, if you just go back to 1920, where the trade movements began to champion for the rights of workers, and you can remember individuals such as Harry Thuku. Sometime about in 1922, Harry Thuku organized for a protest just to fight for the rights of workers. He was arrested and deported. I think it sounds familiar, so some people being arrested and deported also in this age. Deported to Kismayo, where he was held in detention. So citizens in Nairobi organized for a demonstration against his arrest. And the colonial government responded by quelling those demonstrations by shooting at demonstrators. And I think about 25 people were killed in the streets of Nairobi that day in 1925. And this has been the mirror or the picture of every demonstration, especially political demonstrations organized within the country up to today. You'll realize, for example, after that 1922 demonstration, the colonial government completely changed the approach towards demonstrations now. It went towards suppressing them fully. That's why you will see, for example, during the Mau Mau struggle, they enacted, for example, in 1950, the Public Order Act that we currently use up to today. And of course, you know, 1950 was just the period before the state of emergency was declared about 2 years later or so. So this act was enacted with a mindset to limit the right of assembly. So if you use that act up to today, it means you're still using the mindset that somebody who enacted that act 80 years ago, or 100 years now, I think. No, not 100, 75? Yes. Had up to today. And this colonial mindset was carried forward to other governments as well. For instance, when Kenyatta took office, I think one of the early amendments he did, I think, was to the, should be to the Public Security Act at that time, whereby, no, I think one of the first amendments he did was to the Public Order Act, immediately after the one-party system, after he banned KADU. One of the amendments he did was to ban demonstrations that actually displayed flags, T-shirts, emblems that featured any other political party. So again, he carries that mindset of repression. When it came to President Daniel Toroitich arap Moi, I'm not sure how much I should say about it, knowing the venue where I am. But of course,
just remember limitation of rights.
Okay. Freedom of speech is not there.
Freedom of expression.
Yes, you all know what transpired during his presidency. There were amendments after amendments to the Public Order Act, not in any way seeking to protect or seeking to facilitate enjoyment of the right to assembly. They all sought to limit the enjoyment of this right, which tells something about our governments. Why are they so particular in limiting enjoyment of a right rather than facilitating it? Is it a particular mindset that we carry, or is it in their best interest for them to limit rather than facilitate enjoyment of these rights? I don't know, but I think my answer would be they have a particular mindset. And this mindset, I believe, started with the colonial government. Remember when Hari Thuku organized for demonstrations and they were thwarted by about 25 people being killed? The reason the colonial government gave for those actions is that they were trying to overthrow the government. Another familiar excuse. Even as recent as 2024, I believe you had that excuse when the government tried to thwart some demonstration by even invoking the military. And I think one of the justifications were, or one of the stories in the streets were, that there was, quote unquote, a planned coup, which the government, or I don't know by whichever hand they saved the government of the day, maybe, I don't know, through a handshake or through the military or through the special forces, shooting people outside parliament. So this mindset is what I think needs to be changed on this particular right. It also transferred to the Kibaki administration for a little bit. Of course, you know how they handled the post-election violence. Wasn't that good. But during Kibaki's time, there were quite a number of positive things. For example, there was enactment of the National Police Service Act, which contains the 6th schedule. The 6th schedule of the National Police Service Act seems quite an advansive feature, but its implementation is what is worrying. And its implementation was now tested during the Uhuru time. During the Uhuru time, I don't know if many of you are familiar, but I think there were a series of protests which were organized, I don't want to say by my political party, but by another political party. Especially, you remember where after the chicken gate scandal, IBC should go. There was another one, Chebukati must go, where it used to be tear gas Mondays, Machozi Monday. Yes. The objective of that government was always to restrict enjoyment of that right. The response wasn't good. It was always characterized by excessive use of force, characterized by extrajudicial killings. And in the Ruto administration, it has not been different. Therefore, you see this train of activities from the colonial times to the Ruto administration, all characterized by the same thought, all characterized by the same activities. Any protest is thwarted by either excessive use of force, extrajudicial killings, and the justification would always be there was a plan to overthrow the government, or there was a threat to national security. That's why we did what we had to. So why do all these administration across almost 100 years from colonial times to this time, why do all of them have the same thought or the same approach to the right to assemble, demonstrate, and picket? And I think maybe that's the mindset that we need to change about the government. We need to change the mindset to be more of a facilitative view. We need to change the mindset of the government to be a protective view towards this right, to be an enabler towards this right. And maybe that's when we can get it right. But there's also another angle which I know responsible citizens might ask, or courts have already talked about it, that we know demonstrations always turn out to be violent. You can check, I think, in the Hussein Khalid case, and many other cases that have been litigated surrounding Article 37. Then there's always a problem there if you measure it according to international standards, which prescribe some sort of restraint or some sort of tolerance towards the government, where the government is supposed to monitor, put in measures to ensure that actually the demonstrations occur rather than dispersing them, maybe, for example, or use certain amount of force while dispersing demonstrators, or not to use force at all? Do we have sufficient rules in place, or legislations in place, or subsidiary legislation in place to regulate such conduct? I think to some extent we do, but I still think the Public Order Act cannot serve as the source of regulation of assemblies and demonstrations, because it carries the same mindset that was enacted about 75 years ago of limiting the right and of dispersing demonstrators and seeing demonstrations as evil. We need to change that. You would see, for example, repressive court decisions. For example, there's one case here in Nakuru, which happened, I think, about 7 years ago, where pyrethrum farmers just tried to demonstrate the first time. So the owner of the company just rushed to the High Court to seek conservatory orders against further demonstrations. And the court said, looking at the economic status of these alleged protesters, they are likely to hold violent protests. So you can imagine courts of law profiling demonstrators or potential demonstrators using the economic status, which I think it's a very dangerous approach. So we also need to change that mindset of some of the courts. I don't want to point it specifically to a judicial officer, but I want to say that mindset towards demonstrations need to change. And lastly, the mindset of the participants of demonstrations also need to change. Why do I say so? Ali Mazrui, when he was writing his book, The Africans, he observed one thing, that during colonial times, Africans used to rebel against the colonial government by destroying government property or destroying the property of the colonial government as a form of heroism. They saw it as defending their own dignity when they destroyed property belonging to the colonizers. But then this mindset also proceeded to other eras, such as post-colonization. You'd see, for example, during any protest, citizens would always carry a stone or carry something just to throw it at a building, just to destroy something. And then when they come back home, they've become fulfilled that actually we engaged in a successful demonstration, depending on the level of destruction that was there, depending on the level of chaos that was there. That's how citizens would classify a successful demonstration. In fact, some of them would cry that we actually need some tear gas. Some will tell the police, I don't know, the tear gas is
Not strong enough.
Yeah, it's not strong enough, it's expired, I don't know, this one is pink, we want the yellow one. So there's also a mindset of the demonstrators that also needs to change for this right to be effectively realized. And of course, international standards also have a role to play. We have an elaborate volume of procedures, of rules, of regulations, of how demonstrations should be conducted and how the state should behave, and I think it should be under general comment number 37. But I think that's just a story to the state. If they implement it, we'll be having it better. Thank you.
Thank you so much. A round of applause for Cedric. Wonderful overview, wonderful presentation all round. I know we have very limited time and I wanted to hear some comments and questions from the floor. So all I will do is to ask Walter to give a short commentary so that then we can democratize this conversation even further.
I join you, Doctor, in congratulating